Welcome to Chapter 10 of Law in Australian Society, which looks at punishment, sentencing and appeals. This is the second of two chapters looking at the different stages of the criminal justice system. In this chapter, you'll learn about the types of punishments issued by courts, the purposes of punishment and the principles of sentencing, aggravating and mitigating factors, sentencing of Indigenous offenders, imprisonment and parole, and appeals against both conviction and sentence. As a starting point, it's important to remember that imprisonment is not the only punishment that courts can deliver. Courts, as part of a sentence, can also prescribe a community service order, or probation, a suspended sentence, or a good behaviour bond. These are all detailed in the chapter. As one example, probation is the release of a person back into the community on conditions, and this is similar to bail but operates after the person has been convicted. For judges to arrive at an appropriate sentence or punishment for a person convicted of an offence, they need to weigh up a variety of different things. One of these categories of things they need to weigh up are the purposes of punishment. These are set out in more detail in the book, but briefly, retribution involves punishment for an offence. Rehabilitation means helping the offender not to reoffend again by addressing the underlying causes of crime. Deterrence refers to either deterring the community from committing crimes or deterring the offender from committing a crime again. Denunciation is the need to denounce a crime morally, and incapacitation is the need to protect the community by putting the person in prison. The principles of sentencing relate to how a person should be sentenced for a crime. Proportionality means that the punishment should fit the crime. Parsimony means that the punishment should be the least severe necessary. Totality means that when a person is charged with multiple offences, the overall punishment fits the crimes. Consistency means that people should be sentenced in similar ways for similar crimes. And individualised justice means that judges should take into account the individual's personal circumstances. Sentencing judges and magistrates also weigh up aggravating and mitigating factors. An aggravating factor is any piece of information that suggests a punishment should be more severe. So, for example, the person might have used excessive violence or a weapon. A mitigating factor is any piece of information that suggests the punishment should be less severe. So it's possible that the offender had a difficult upbringing, including sexual or physical abuse. This can make the person less morally responsible for the crime they committed. Instinctive synthesis is the overall process used by a sentencing judge to arrive at an appropriate punishment. It's essentially a subjective decision-making process in which all of these things, the nature of the crime, the circumstances of the offender, the purposes of punishment, the principles of sentencing, aggravating, mitigating factors, and any other relevant factor, relied upon by the judges to determine an appropriate punishment. This is often contrasted with a two-tier approach which has been rejected by the courts. A two-tier approach would involve setting appropriate penalties for certain offences and then adjusting that according to personal factors. This is seen as being too significant a restriction on a judge's discretion. The chapter also looks at mandatory minimum sentences. So for most criminal offences, there's a maximum penalty set. If the legislation says the crime is punishable by 14 years imprisonment, that's the maximum, the ceiling, that a sentencing judge can reach. Occasionally, though, Parliament will set a minimum penalty that judges and magistrates must apply, and they cannot go below. This is controversial because it substantially reduces the judge's discretion. Mandatory minimums can also impact disproportionately on Indigenous offenders because of their increased contact with the criminal justice system. Mandatory minimums received substantial media attention after a minimum penalty of 8 years imprisonment was introduced for a New South Wales offence of assault causing death in response to high-profile cases of alcohol-fueled violence and one-punch attacks. The chapter also considers how courts sentence Indigenous offenders and whether this is any different to sentencing non-Indigenous offenders. It details Indigenous courts and circle sentencing practices that have been established across the Australian states and territories. Courts can also take into account a difficult personal background of any Indigenous offender, but only in the same way as for any other offender. After a person has been convicted of a crime and is serving a prison sentence, they can be released on parole. So parole is when a person is released into the community on conditions. This is similar again to bail or probation, but it operates while the person is serving a prison sentence. If a parolee breaches their conditions, they can be returned to jail. Finally, the chapter considers appeals, and this relies heavily on the court hierarchy. A person convicted of a crime can appeal against either their conviction or their sentence. They can appeal against their conviction on a question of law, or less commonly on a question of fact with the leave or permission of the court. This can lead to a conviction being overturned, either if the judgment was considered unsafe and unsatisfactory or there was some other miscarriage of justice. A convicted person can also appeal against their sentence if it was manifestly excessive. So the court is not considered a court of adjustment. They can't tweak a penalty by a small amount. But if a sentencing judge delivered an excessive penalty, then the person could appeal against that. It's also possible for the Attorney General to appeal on behalf of the prosecution if a sentence was manifestly inadequate. So to reiterate the key points from this chapter, the role of a sentencing judge is to arrive at an appropriate punishment for each offender. Sentencing judges consider the offender's conduct alongside many other factors, including the purposes of punishment and the principles of sentencing. Aggravating factors suggest that a punishment should be more severe, and mitigating factors suggest the punishment should be less severe. Appealing a court decision means challenging it in a higher court. This can be done on a question of law, or more rarely, on a question of fact. A convicted person can also appeal against their sentence if it was manifestly excessive. Some discussion questions for your lectures and tutorials. Aside from imprisonment, what other types of punishments can courts deliver? What is the difference between the purposes of punishment and the principles of sentencing? What are the advantages and disadvantages of a judge having discretion to determine an appropriate sentence? Why are mandatory minimum sentences controversial? Do you think that having mandatory minimums for some offences is a good idea? Is the sentencing of Indigenous offenders any different to the sentencing of non-Indigenous offenders? And finally, if a case begins in a local or magistrate's court, what are the different levels of appeal it can progress through?